For what?
My lord, for the extension of time, my lord, this is the fix at the 3 p.m. My lord, this is the appearing the Deepnath Roy Chaudhary.
What the court told you? Come when the matter will call. Why you are mentioning again and again?
May I have my lord's leave, my lord, to mention item 64 of my lord's list.
Yes.
This is an execution application filed by us with regard to a decree on consent, my lord, passed recording terms of settlement in an admiralty suit, my lord, where the plaintiff and the owner of the vessel have settled the matter on 9th of September 2024. Now, what has happened, my lord, the disponent owner of the vessel has invoked the arbitration clause.
Yes, yesterday somebody.
I'm sorry, my lord. Actually, I'm sorry, my lord. I just came to my lord to apologize. My lord, there's some urgency in the matter, but yesterday, my lord, I mistimed it. I thought, my lord, after 2, my lord is not going to take up these matters. So, my lord, I accepted, my lord, something else. My lord, what's happened, my lord, in breach of, my lord, the decree. It was, my lord, a decree by which, my lord, everything settled. Now they've started, my lord, an international arbitration. The same people, my lord, who were defendants in the suit. So, my lord, we wanted, my lord, an order of injunction. Whenever it's possible, my lord, today, tomorrow, my lord.
7 days.
My lord, because they had given us, my lord, 7 days, my lord, to appoint an arbitrator. Because, my lord, knows international arbitration, my lord, if it starts.
When the 7 days going to?
My lord, 7 days, my lord, is tomorrow. Tomorrow. My lord, it won't take more than, my lord, 10 to 15 minutes. Not more than that. There's a decree. There are, my lord, clauses in the decree. And, my lord, we've got the, my lord, judgments, my lord, which also, my lord, have the, my lord, law with regard to that.
I don't fix it.
Today, my lord, has fixed, my lord, my other matter, my lord, at 2 o'clock.
That already fixed.
Yes, yes. My lord, after that or before that, my lord, whatever's
2 and 3:30, 3 o'clock already fixed. 3:45 fixed. Yeah.
Because that may not, that's one of the section 12A and section 8 matter, my lord, which is, if possible, my lord.
Huh?
So this is my lord, 10, 15 minutes at most, my lord, I'll take, not more than that.
12:30 भी है. No, कल चाहिए, आज चाहिए. Going to tomorrow? Tomorrow is the last date.
Tomorrow, my lord, is the.
कल 10:30 बजे, कल तो फिर रहेगा. कल में दोनों फिक्स है, सब फिक्स है. कल
Today 2:45 minutes should be tried, my lord. Today 2:40, my lord doesn't have anything else fixed.
2:30 क्या है?
Because that matter, my lord, may not take.
Come at 2:45.
Very well. I'm so grateful.
My lord, may I have your lordship's kind indulgence to mention, my lord, this matter, my lord, was pleased to extend the time of the commissioner to file his report. And my lord was pleased to grant me leave to file an affidavit under section 65B of the Old Evidence Act. My lord, only thing, my lord has been pleased to direct me to file the document within a week from date, paragraph 2, my lord. My lord, the witness is traveling abroad, my lord, for his medical treatment. My lord,
Are they concerned for the liberty to file the affidavit under section 65B within a week? Yes.
My lord, what I was humbly praying, my lord, only that the phrase within a week from date, my lord, if that could be struck out, my lord, the date the commission will be held, my lord, will file before the commissioner.
That is the problem. That is the problem of the bar.
He is traveling.
Once the court is granted time, you are not adhering to the time. Every time you are coming, mentioning, waiting the 15 minutes time of the court in the first hours itself. In this order was passed in your presence.
I apologize, my lord.
Let the client go, whatever. Let the client roaming around the world.
My lord, it was my mistake, my lord. I could not listen to my lord's order.
I didn't find any order have been complied with any of the parties where the commissioner has been appointed. The matter is mentioned by the learned counsel for the plaintiff.
Yes, my lord, I am mentioning
the plaintiff. Submits that by an order dated 16 July 2025, this court granted leave to the plaintiff to file affidavit under section 65 within bracket capital B of the Evidence Act before the commissioner within a week. So the counsel for the plaintiff submit that the plaintiff is out of station and due to which it is not possible for the plaintiff to file affidavit within a week and prayed for how much time?
Well, the commission will be held within the time frame. We will file before the learned.
No, I will fix the time. Otherwise, you will never file the affidavit, nor the commission will be held. I have good experience with all of you. You have no knowledge when your client leave at all.
My lord, my lord,
Call the matter.
within 2 weeks.
My lord,
Call the matter.
Within 2 weeks.
Yes.
my lord, may I,
Within 2 weeks.
No further time. Yes.
my lord, may I seek your lordship's leave to file 2 documents, my lord? What has happened, my lord? On 16 June, my lord had directed me to file affidavit of evidence and judge's brief of documents within 3 weeks and 2 weeks from the date.
When the date is fixed for evidence?
4th August, my lord.
4th August is the undefendant suit,
Yes, my lord.
and even come on that day with all documents.
Deep,
Yes.
Your Lordships, may I mention CS Com 38 of 2025. Lordships, the commission was going on, your Lordships. The Lordships, in the last meeting, the chief had ended. Your Lordships, the defendant had sought time to mention the matter. However, Lordships, the matter was not mentioned.
Why it is
Your
to be
Lordship, I
mentioned?
am appearing on behalf of the defendant, your Lordship. We have already given a notice for mentioning yesterday only.
Why?
Your
The
Lordships,
reason being, after the examination in chief has been
Of the plaintiff witness, defendant witness?
plaintiff witness, your
Ah.
Lordship, it is only there. It has been concluded, and thereafter only I'm mentioning, because certain documents cannot be marked as exhibits only. So before I commence my cross-examination, I want to bring it to your Lordship's notice as to whether those documents could at all be marked as exhibits.
Document has been inspection has been carried out. Affidavit of evidence, affidavit of admission and denial is filed. What is that has to go by the affidavit of admission and denial of the document. If you are denied, it will deny. It is not denied. It will be exhibited.
Not true. It cannot be marked as an exhibit, your Lordship. I must.
If you are denied in the affidavit of document, the document which you have inspected, have you denied in the affidavit of documents which you have filed?
That I'll have to.
Then, without
But
seeing how you can say that it has to be objected,
because your Lordship,
the commissioner has to go by the affidavit of document which you have filed.
Your Lordship, I must respectfully submit, in this appointment of the commissioner, no power was given as to adjudicate whether a document can be marked as an exhibit.
That's why I'm telling, sir. That's why I'm telling,
No.
because as far as this court, unless and until the affidavit of admission and denial is not filed, this court is not framing the issue.
Your Lordship, if
And thereafter the evidence has been taken up.
there is no admission and denial filed, as I have not been instructed that any admission and denial has been filed in this matter. Which is why I'm submitting before your Lordship. There are certain documents which cannot be marked as exhibits, should be ought to be marked as a mark for identification. Hence, before the
It is not yet, you're not yet started the cross examination. First you start the cross examination. If you find difficulty, let them answer before this court.
good for your Lordships.
First to start the cross examination. If it has any difficulty for exhibit or objection, come before this court. You're not yet started.
because your Lordship,
You will start from the document itself.
Your Lordship.
Yes.
Great,
Call the
your
matter.
Lordships.
Lordship, may I be permitted to mention a matter, your Lordship? Lordship, this is APCOM 91 was heard yesterday, your Lordship, and the matter was fixed on 24th. I'm being led by Mr. Anirban Ray, your Lordship. Lordship, the issue is he is not available till 1. Lordship, so I was praying if a date can after first.
It will fix on the 28th, my lord. I don't want to listen to your Lordship's diary, my lord. On that, if I could prefer some time and my lord,
Notice to the other side.
All the parties
Yes.
are
Appearing, but only difficulty is that there is some. I have indicated to your Lordship, there is some urgency in the matter. If they will not sell off the assets, the value of the shares will go down. So
there is no opportunity of selling.
Application has been filed by my client. Now, if
I was only requesting for 2 days, my lord.
if they can do it,
2 days, my lord. Before the first
it's fixed day
court,
after.
any day, my lord. 28th, not here, my lord. I was not properly instructed, my lord, yesterday. That's why I could not appear, my lord.
We can come back with.
But only 1st, 4th, 6th, whenever, my lord. Only that till 31st, my lord, I have some problem, my lord. If Lordship could kindly, my lord.
When it is fixed on?
24th, your Lordship.
Day after, I can come back tomorrow.
Then when you will be available?
From first, your Lordship.
First.
So the first one. But this.
Without the
My lord,
vacation
can keep it on the
going
court.
on?
No, my lord, it's for some personal matter. It's for a professional matter. I will not
No vacation, sir.
lie before you. But no, it's a professional matter, my lord. For that, I'm going. My lord, kindly give us on 25th, my lord. If your Lordship takes on 25th, my lord, I can. My lord, if your Lordship kindly permit.
25th you will be available. 25th of
Yes, yes, I'll come back. I'll come back.
Commercial है. Let it fix on 25th.
25th. Obliged.
I'm so grateful.
I'm very grateful, but I'm very sorry, my lord. I'm very sorry for yesterday. Could not-
Do one thing, let it become tomorrow as to be mentioned, and I'll be
Obliged.
Grateful, my lord, grateful, grateful.
My lord,
yes.
May I pray for one more attempt?
No, sir. If you are not confident with your client, which date your client will be available, you are mentioning without taking the instruction from the client and mentioning the matter before the court. You bring the senior persons.
My lord, I'll ensure that the order is complied with.
क्या बोला उसमें? Wait for 2 weeks, further 2 weeks time to file the affidavit under section 65B of the Evidence Act. Considering the circumstances mentioned by the learned counsel for the plaintiff, time to file affidavit under section 65B of the Evidence Act is extended for a further period of 2 weeks from date.
Great.
Next, call the matter. Mention. 11:30 का है? 11:30 दो.
My lord, before that, may I mention item number 2, my lord? The other side had mentioned this matter, my lord, praying that the matter be kept on Thursday, my lord, because senior, this is the Money Square Pyramid matter. Lordship had heard it on Friday, my lord, on the 18th.
My lord, I appeared for the respondent, my lord. I had mentioned this matter yesterday, my lord, for shifting, as there was some 10:30 matter fixed today. My lord, if it's subject to your lordship's convenience, my lord, can it be at 2 p.m. on Thursday? Your lordship had indicated, my lord.
Please, my lord.
Thursday 2 p.m.
Grateful, my lord.
Thursday 2 p.m.
Thursday 2 p.m.
Grateful.
Grateful, my lord. Deeply obliged, my lord. Grateful.
Yes.
Item 1 was for disposal. Item 1 was for disposal. Your ship settled very well.
Yes.
Before I come to the last leg of the argument on fraud, there's one decision on the issue of property being sold, decision of the Honorable Supreme Court, which clinches this issue in my favor. That if the court will see the compilation are originally filed. I refer to that judgment for a different proposition, but that judgment also has paras which are relevant for this point of what you mean by property sold. The very first case, 2008-14 SCC, page 258, relevant part is on page 7.
Yes.
Page and para 10 is where the whole issue is.
Page 7.
Page 7, para 10 is the court extracts Order 21 Rule 58. I'll read from para 11. It is pointed out that by the learned counsel from the language of clause A of the proviso to Rule 58.1, that where any objections are taken to the attachment on the ground that says property is not liable to attachment, the court has to proceed to adjudicate upon the claim of objections in accordance with the rule. Learned counsel further argues that there is a right to this rule in the shape of a proviso, and it suggested such claim of objection need not be entertained where firstly the property attached has already been sold. Learned counsel points out merely because the auction of the suit property, it cannot be said that the property is sold, thereby leaving no right opportunity for the objector to object to the attachment. Learned counsel invited attention to so-and-so, decision of the Andhra Pradesh High Court, where a similar situation had arisen on the basis of an application made by the appellant under Order 21 Rule 58 CPC. Objector was none else but the son of the judgment debtor whose property was auctioned. The objection was that there was a prior lease respect of the suit property, and since pursuant to that lease, appellant objector had been possessed of the same, and therefore attachment was not valid and had to be vacated. Objection was also raised that property which were attached were already sold, therefore the objection to the attachment appeal had become infructuous. The court therefore dealt with the effect of the court sale conducted by the lower court. It was admitted position that before the said order of the High Court reached, the sale was already completed in respect of all the items where the decree holder himself had purchased the property. It is also seen from the fact that the sale was not confirmed. The division bench, speaking to Honorable Justice Rao, observed in para 15, wherever a claim is preferred under Order 21 Rule 58 CPC against attachment moved properties, the fact that the properties are sold or the sale confirmed will not deprive the court of its jurisdiction to adjudicate upon the claim. The inquiry into the claim can be proceeded with by trial court or the appellate court under the amended code. And in the event the claim is allowed, the sale and confirmation of the sale shall to the extent be treated as a nullity and of no effect, as the judgment debtor had no title which could pay to the court auction purchaser. If I become straight to para 16 on page 9, on
Yes,
the basis,
already on the last occasion also.
I've argued, but here the issue was because in light of the order 17th August, which I read out, I'll read that order again. I just read out one line in that. The order itself says that because the suit cannot have the arbitral award cannot be the subject matter of the suit, it is for that reason we cannot give any relief here. We can still seek relief outside that particular suit, and that's the reason we are modifying the award, retaining the identity till the orders are passed in the execution proceedings. The execution proceedings had already been stayed by that point of time, so there'd be no order. Execution proceedings were stayed on 12/5/2015,
Correct.
and then subsequently adjourned sine die.
Correct.
So, if the property is still in the season of the court, it is not complete, even though it may have gone from the account of Augustus to Ascot. That does not deprive this honorable court of the jurisdiction to adjudicate the claim even for that 28 crores. And that is what I'll just read just 2-3 lines more from the judgment. Just 2-3 lines more from the judgment. I'll take you through the court to that order, and that's the end of the submission.
Yes.
Page 16, page 9, para 16. On the basis of these two judgments, the learned counsel urged that the objection, application, the execution petition could not have been thrown away at trial by the trial court, and the High Court as not being maintainable. Considering the law laid down in so-and-so, it must be held that mere holding of auction does not bar the objections thereto. In our considered opinion, that is, in this case, the sale was not confirmed, and that made a substantial difference. The word sold in clause A of provisor to Rule 58 has to be read, meaning thereby a complete sale, including confirmation of the auction. That not having taken place, it cannot be said the objection plaintiff was ill-founded, untenable. If I come straight to the next page, para 10, on page 11.
May I have your lordship's kindly?
Yes.
Para 11, page 11, first line. It is from the same judgment, but it is clear that as long as the sale is not confirmed, the status quo ante can be restored. In case a claim is allowed, it has been held that once a claim petition is allowed, the sale be treated as void because the interest of judgment debtor that was sold did not in fact belong to him, like in this case. And the court auction purchaser would not get any title in the property as the judgment debtor had no interest therein, and because the claimant continues to retain the interest in the properties after the extracted portion. These observations will show that the Andhra Pradesh High Court not only considered the language of Rule 59 impact thereof as clearly displayed, but also went to consider the fact of prior obligation regarding the object in the property, and the fact that even the sale is affected under Rule 58, it cannot obliterate the claims of the objectors which were created prior to the sale. Now, in light of this proposition, the court may just see the order at the top of the court with this one order of this honorable court in the compilation of orders, 17th August 2015. And I'll just read the entire order to make it very clear, because this
page number
19. The court will be pleased to recall that on 14 May 2015, the suit had been there was partial rejection, the suit was still pending. This is subsequent to that, because GAs were filed. Yes. Seeking enforcement that we please injunction, we grant injunction against enforcement of the award. So this is the order passed by this honorable court. I'll read from page 19 itself. This application is made for recalling and or modification of the order dated so-and-so. On 14 May 2015, I delivered a judgment in an application filed by defendant number 1 for rejection of the plaint holding inter alia that the prayers for setting aside the award in the suit is barred by law, and the suit, insofar as relates to the setting aside of the award against the defendant number 1 is concerned, is not maintainable. On 29 July 2015, I dismissed the application being GA so-and-so. Mr. S.N. Mitra, learned senior counsel, appearing on behalf of the petitioners, amazed that this application being GA so-and-so was never heard of merits, inasmuch as, in spite of giving notice and directions of filing affidavits, the respondent number 2 has not filed any affidavit. Having regard to the observations made in the judgment, I see no pass to pass any order of injunction against enforcement of award. Judgment covers prayers A, B, and D of the application. Whether 3, 4, and 5 would have authority to present the pro forma defendant was also touched upon and considered at the internal page 56 of the petition. Mr. Mitra would submit that so far as defendant number 2 is concerned and further relief suit survives, there cannot be any dispute with regard to the fact the suit was dismissed against defendant number 1. Insofar as other reliefs are concerned, observations made in judgment are on a prima facie satisfaction being recorded about the conduct of the other defendants in the suit. Let it be made clear that the suit against other defendants survives. By reason of the judgment delivered in the demurrer application, I cannot allow the prayer preventing defendant number 1 from executing the award as the same is not sustainable. However, Mr. Mitra, learned senior counsel referred to the order dated 30th July 2014. This is where they said till 6 August. And we don't have the complete order sheet.
Yes.
We'll see what are the orders passed in between. Passed in the interlocutory proceedings, which requires that the beneficiary of the award has retained the funds received by it from the receiver in his bank account or accounts. This interim order was passed when the demurrer application was pending. The petitioner says that the respondent number 2 would misuse the sum which it had received as beneficiary of the award. Petitioner may have any claim against the respondent independent of the award. The money in terms of the award has to go to respondent number 2, who is the beneficiary of the award. Thereafter, the petitioners are able to establish that the petitioners are entitled to recover the said sum. Petitioners can make such claim, but not on the garb of challenging the award. The petitioners say that since the award is fraudulent, the respondent number 2 is not entitled to receive the amount. The subject matter covered by the award cannot form the basis of the suit. Right now, we're in objections. If the award is upheld, then the respondent number 2 cannot be prevented from utilizing the award. In the absence of any challenge to the award and having regard to the judgment dated 14 May 2015, where the learned single judge had recorded that we have to file executions, go in execution. That was the submission, go in execution.
Correct.
I modified the award only to the extent that respondent number 2 as beneficiary shall retain the money subject to any order that may be passed in the execution of the award. This order will not prevent the petitioners from seeking restraint order on the said sums retained by the respondent independent of the award. And hence, the award itself was modified. Or the previous, on 12th May 2015, execution already been stayed. This order is dated on 14th September. The court will see on page 22, there were slight typographical errors which were corrected, which are important.
Retain any amount.
On page 20, on page 22,
yes.
14th September, it appears in the last but one sentence of the continuing paragraph instead of order dated 29 July 30th gone down as award at page 2 of the said order, the last paragraph, 5th sentence on the bottom, instead of which requires beneficiary award is retained, it should read as which directs the beneficiary to award to retain,
any.
if any. So that we didn't know the money is actually gone or not. The submission, short submission is this. As far as the 28 crores is concerned, in the suit itself, the award itself was modified to the extent that the beneficiary will retain that money subject to any orders being passed in the execution. Because I could not do it in the suit, they say go and do independently, and I've done that. I can do that in my objections.
Correct.
Now, on the execution side, the execution of the award itself had been stayed way back on 12th of May 2015 prior to this order. That is on page 16.
So this was not brought to the notice of this court when this order was passed.
Apparently not. But there also, if I may just say, the execution proceedings were not stayed. Execution award.
No, that's why the court has passed an order.
Yes.
I modify the award to the extent respondent beneficiary shall retain the money subject to any order passed in the execution.
So that is, but the execution of the award had been stayed, not execution proceedings. So that was still further orders. The court will be pleased to see it was still further orders. So on the civil side,
and this order is continuing. 12th May order.
Yes.
12th May order is continuing
till date. There is no further orders revoking this.
There is no order.
On the contrary, on the court will see page 23, let the matter be adjourned sine die. It got adjourned sine die in 2016, and then it remained a sine die till we came and filed objections. In view of the fact.
No, learned advocate appearing on judgment after submit the appeal is still pending.
Yes.
Prefer adjournment of the sine die.
Sine die.
Appeal dismissed.
Then appeal dismissed in 2019.
2019.
And then we filed our objections straight away.
Then Supreme Court. And in the meantime, you file this application. And this objection is going on.
Yes. So my
no further order in the execution.
In the execution. So my respectful submission is, one of course says that 42 lakhs is itself sufficient to sustain the objections on maintainability. I'm not saying I want 40, 42. I want 28. But that itself is sufficient. But even 28, there's been no completion of that sale.
Got it.
In view of the Supreme Court judgment.
Got it.
And this, in any case, is a matter of trial.
Okay. That's why if this court find that this has to be heard.
This has to be heard.
Then it has to be heard on merit. If it is heard on merit, and if we find automatically that
no, even the proviso for that have to lead opportunity. Even for proviso, whether there's delay and whether it has been sold, have to lead evidence.
Correct.
So that is the other judgments I cited. So
Yes.
this was my submission as far as this. Under section 430, I've already concluded. Only one line I want to add there. In the affidavit in opposition, they've not even raised the defense of section 430 Companies Act. It's outside the pleadings. So they have tried to argue something which is not in the pleadings. That's only one line I want to add. Now I come straight to the fraud part. Now, as far as fraud is concerned, my learned friend, when he started his reply, his very first line was that the learned arbitrator has said that press note 2 of 2005 applies. So in a way, implying there's a finding by the learned arbitrator that I was supposed to bring that 5 million. That is factually incorrect.
Why?
The award, I'll take the court to the award. The award simply says, traces the history, simply says that there's a petitioner is saying that they got to pay 20 crores. Augustus Neeraj Pandey is saying, yes, I have to pay 20 crores because of that admission. I'm passing this award. Court will be pleased to see the award from it. Only one line.
That's so, yeah.
Only one line from that award. I'll just take the code right till the end. The final operative part, last page of the award. That's all.
Yes, from the aforesaid, it is clear
Very
that
clear
the
that the
company
company is
admitted.
admitting its liability. It's based on admission. There's no finding on merits. Admitting its liability to investing to some amount of rupees 20 crores in the joint venture company, and its stand is it has carried out the obligation investing the amount by 2 checks. The stand of the respondent company that the 2 checks were not in cash for reasons beyond his control. However, the fact remains that the respondent accepts his liability of investing the amount of 20 crores in claimant company in furtherance of this obligation under the joint venture agreement of 2007 in terms of press note of 2005. The JV of 12/7/2007 does not have any contractual term of 5 crores. The press note 2 of 2005, which talks about 5 million, is inapplicable to our case as per the government approval letter. And I'll just come to that in a minute. But the admission is that as per JV, I have to pay. As per press note 2, I have to pay. And I'll show how this is fraudulent. And they knew it. Then the court will be pleased to see that, that the question was put to me, what was the amount awarded? The 20 crores with interest at the rate of 9%. So that's 42 lakhs is part of the decreed amount.
Correct.
So this was what fell from the court yesterday. What was awarded? This was what was awarded. So the first point is the learned arbitrator has proceeded on admission by the rogue directors that I have to pay 20 crores. There is no finding that press note 2 applies. That's a gravamen of my learned friend's argument.
That's why the tribunal has said, okay, you are admitting the 20 crore.
The rogue directors of Augustus, not me.
That's why both parties.
The JD. I'm Starlight. It's my money.
You are not there.
Yeah, I'm not there.
You're not there.
Yes.
And but the claim was the 5 crore.
Yeah.
But the court has found, the tribunal, the learned tribunal arbitrator has found that there is no claim sustainable with regard to the 5 crore. That's why
no, 5 crore was damages.
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 Yes, damages. Damages has not been proved, so damages has not been